you need to, before you set off on any procurement process, think really, really clearly about your award criteria. And here, quite rightly, as has been trailed, we've gone from meet to MAT. So meet stood for most economically advantageous tender, and now we've just gone to most advantageous tender. And I think this is a decoupling or a point, signpost to the fact that Advantage has all sorts of things with it. It's not just economic. People thought too much about pricing, maybe. It's overall advantage that we should be driving out of public procurement processes. And certainly from a previous fire safety perspective, 10 years ago, it was maybe acceptable to go out with an 80-20 split, 80 on price, 20 on quality, because you said we've got a really limited budget for this safety project. I think if you try to do that now, you might get a lot of funny looks, and that you really shouldn't be doing that. There needs to be a really, really careful balance between your approach to price and quality on fire safety projects. So one of the other really big changes in terms of the Procurement Act 23, and this is around the transparency regime. There are 17 different notices that have come in with the new regime, and from a procurement perspective, it's a little bit like now doing your job, in front of everyone at Wembley Stadium. Everyone, including disappointed contractors, residents, tenants, everyone, and you might say quite rightly, can look into your procurement process and see what's happening. You've got to publish contract award notices, contract details notices, setting out exactly who won and why, quite rightly again. The big thing, though, is that you've got publication of contracts. So if you've got a project that's over £5 million and you've gone out under the Procurement Act 23, you then need to publish the full contract online once it's been awarded. So obviously you've got to get the approach, the commercial terms right, and all the legal terms right, because if you try and award the contract to the winning bidder and then they require a whole series of changes, you're in quite a difficult place agreeing to those, because everyone will be able to see how you've kind of flip-flopped afterwards. And then the disappointed bidder might be going, well, hold on a minute, if you'd offered me those terms, I'd have come back and won the process. So actually, there's vastly more transparency within the regime now. Also, just to say, the Procurement Act 23, previous procurement law only covered really the procurement section of the whole piece, so up to onboarding the contractor, and it kind of petered out at that stage. The new regime really, really goes down into contract management in a lot of detail. So looking at documenting contract changes, understanding how contract changes are permitted in accordance with the Procurement Act, and then also being highly transparent about what changes have happened, because the vast majority of changes will again need to be published online to keep everything up to date.
Okay, so what I've done is I've gone away and I've had a talk to our operational teams to find out what people could be doing better. So like I said, over 50% of the building control applications we're receiving at BSR are rejected at the very first stage of the application process. So I'm hoping it will be useful for me to go through some of the key documents which people are falling over on. And I think I want to emphasize again that we want the same thing here. We want a quick and efficient building control process where everybody at the end of it gets safe building work done. We want building work to be safe, but we want it to be efficient. We know that you want to carry out work, and we aren't here to be a block. We are here to make sure that the work being carried out is done to the right standards and is safe, crucially. So the chief reason, as I've said in the last slide, the chief reason applications are rejected is we simply don't have sufficient information upfront to make an accurate assessment of application. We need the relevant information at the time of the application to be able to progress with the application and put together an MDT. You're applying to us to demonstrate that the work is complying with the relevant building regulations. I mean, given who's on the call today, a lot of this will be around Part B. So we need all the information required to satisfy this upfront. Anything less, crucially, will be a waste of your time, but also slows down our operational teams, because we're having to scrutinize documents and scrutinize applications, which in the end don't make it. So one of the most common issues we see, I keep banging on about the meeting the functional requirements of the building regulations, but this is what we're looking for. So making reference to how you're meeting those functional requirements of the building regulations in your documents is a really, really good way of emphasizing to BSR that you're approaching this from the right angle. So when we're receiving plans and drawings, making reference to building regulations is a really good way of going about it. So what we get quite often is we get design drawings, not plans relevant to the building regulations. And this takes me on to the next point, which is the competency declaration. So this is often an area which is insufficiently detailed. So we need to see that you've taken reasonable steps to make sure the persons carrying out the work are suitably competent to do so, which the last talk went into very well. So it's a very important step in showing us that you're managing and carrying out the work to a good standard. Again, referring to the regulations is a great way of reassuring us that you're making the appropriate considerations in terms of competency. So similarly, what we're looking for with fire information is relevance to the work being applied for. So what we see a lot is applications providing to us the entirety of the building's fire evacuation plan without an attempt to relate it to the building work that's taking place. So firstly, it's great that you've got a whole building fire evacuation plan, but what we need to know is how the building work you are carrying out integrates with said plan, and how any work you're doing may well affect evacuation or anything to do with Part B. So similarly, a fire risk assessment is unlikely to demonstrate us what we require. Referring to the regulations again, I'm going to bang on about it, it's always a good rule to work to. And then next, what we find is we get questions about what we consider to be 15% of the proposed work for the commencement statement. So details of what you consider to be 15% of your proposed work is often either missed out or, like I said, is insufficiently detailed. Or we get asked how we want to judge 15%. It is up to you, and it's completely dependent on the work you are applying for, hence why it's your responsibility to make the judgment. But again, it's about demonstrating that you understand the work that's being done and how you are going to manage its progress. And then that brings me on to the client statement. So it's another common shortcoming where the application is made by someone on behalf of a client, they must provide a statement signed by the client confirming they agree to the application being made and the information that's provided is correct. There's no set format for this. It's just we need to receive that statement which is signed by the client. And finally, we're more than aware that BSR sits within HSC, but what we quite often get is focusing on health and safety requirements rather than talking about how your application is meeting the functional requirements of the building regulations. So what we may well get is a construction phase plan when we want a construction control plan, for example. But again, I want to emphasize that we both want the same thing. We both want approvals to take place, but we need to make sure that that the work being done is meeting those functional requirements of the building regulations.
I'll start with this picture actually, partly because it reminds me of an email in the disclosed in the early phases of the inquiry, which said that the purpose of overcladding Grenfell Tower was to improve its appearance, particularly when viewed from the conservation area in West London. The conservation area in West London is where this photo, well, a conservation area in West London is where this photo is taken from. And just something to reflect on there. I mean, this was a one of the things which I probably won't get onto so much today, but one of the things that the report found was that the overcladding of Grenfell Tower was actually not done for thermal efficiency reasons. The council had no assessment of the thermal efficiency of Grenfell Tower at all, which would have justified overcladding it. And instead, it was done with aesthetics in mind. It was genuinely an aesthetic process, not a building science process. And I'm not saying that's the cause of why it became a disaster, but I think that it illustrates a lack of concern for what the building actually needed, and particularly what the people who lived inside it actually needed. That absolutely is part of the story. So just a striking image to start with. So it's been a long process. The Grenfell Tower inquiry, as I alluded to at the top, we actually started right back in June 2018. So more than 6 years ago now. And we started with a review of the events of the night of the fire, the sort of minute by minute breakdown of what happened on the night, and then we moved on to this second phase, which is what we've just had the report from, which really took the question why was Grenfell Tower in the condition it was in on the 14th of June 2017? You know, and that question turns out to be a very, very broad one, which leads us into the sort of nature of the construction industry, nature of the economy, even the way we're governed, the degradation of the London Fire Brigade, and all kinds of other themes. So briefly, what's next? There will be criminal charges for, well, there will almost certainly be criminal charges for the Grenfell Tower fire, but they're quite a long way away. I think it's likely to be the end of 2026 when charging files are passed to the CPS. When a charging decision is made by the CPS, and then if there are any trials, they're unlikely to start until midway through 2027. But I am personally, my expectation would be that there will be various parties within this story charged for a number of offences up to and including manslaughter. There were a long stream of recommendations given, which include a redraft of approved document B, a new construction regulator, and then a requirement that contractors who are working on higher risk buildings are registered and can lose that registration if they don't perform, and that we have fire engineering oversight on all high risk construction jobs. Those changes are aimed at improving competence of the industry and increasing individual responsibility and accountability. But what we're not going to get are sort of US style prescriptive building codes, which simply tell builders how to build. We're going to keep this system that we have now of functional requirements. So the responsibility being placed on effectively the private sector builders and their advisors as fire engineers to work out how to make a building safe. That's if the government adopt those recommendations. It's going to take 6 months to consider, and then it's going to present its approach to Parliament.
Section 20, consultation for leaseholders. Does that fit into the slide? I think that was on. I think you've actually answered this, so I'll let you just go with that.
Just very, very briefly, that where you're able to, and it's not universal, there are some protected areas where you're not allowed to recharge for building safety works. Where you are able to recharge, think very carefully about how leaseholder consultation and use of pre-existing frameworks works. It doesn't work. They legally don't go together. So you can't use full consultation, or you can't do a compliant consultation where you're using a pre-existing framework. So you might need to apply for dispensation. But yes, plan very carefully how your leaseholder consultation is going to fit in to the whole of the procurement process. It works if you're doing it independently yourself, publishing an advert, but it doesn't really work very well using a framework. Then that's probably the takeaway from that.
Thank you, Richard. On to Josh. There are many questions for the BSR. I will try and pick one. Okay, just because we've just spent a large amount of time talking about cladding, I'm not sure how much you can mention on this. Is the BSR intending to focus or expedite in some way applications for cladding remediation works?
So that would be an operational decision, and but in light of the BSR is not really able to comment on anything in light of the recent inquiry. As Peter mentioned, it's going to take the government 6 months to respond, and it wouldn't be appropriate for individual organisations to make comment before that official government response is out. But we are aware of the desire to get remediation work on cladding done as soon as possible, and this is why BSR is trying to do as much as it can to improve its processes and make sure that we're seeing to applications quickly, but not to the detriment of the quality of the regulatory process, if that makes sense.
One for you, Peter. In your opinion, if stay put been abandoned earlier, acknowledging the circulation spaces were smoke logged almost immediately, and prior to London Fire Brigade realising the compartmentation had failed, how could the residents have self-evacuated through these routes and the single staircase simultaneously without serious levels of fatality occurring? So I guess what they're saying is if the stay put policy wasn't in place, would people have been able to evacuate safely anyway?
Yeah, I mean, it's a really interesting question. I think it is one that the inquiry report did turn its mind to in the sort of mini inquest phase, which came towards the end and is recorded in volume 6 of the report. And the answer is essentially, for some people, yes. I mean, some people could have made it out. It's fairly clear that there was the communal lobbies were smoke logged immediately, but it took quite a long time for the single staircase to fill up with smoke. And in that time, there were people who were undoubtedly able-bodied enough to cross the lobby and make it to the stair where they would have been safe. And I mean, that's. I think we can say that with confidence because of the amount of people that did escape. You know, there were nearly 300 people inside Grenfell Tower, and within the first hour of the fire, more than half of them had got out, and people were still escaping without assistance up until about 4 o'clock in the morning. There are some people who wouldn't have been able to, particularly people with disabilities, with very, very young children, with breathing difficulties, perhaps, and you know, the report kind of does go through piece by piece. And also, I think it's fair to say that I think once this fire started, regardless of what the London Fire Brigade did, it would have been a fatality fire. Some people would have died. But I think it's beyond doubt, looking at the evidence, that if different advice had been given to residents, if they'd have been told, as compartmentation failed, this building is now a too risky place to stay and you need to leave immediately, far fewer people would have died. You know, it would have been a difficult escape for many of them, but it would have been possible. But that's tough, because I mean, I think this is all benefit of hindsight, because if the London Fire Brigade's incident commander had made that decision and 5 or 6 people had died on the stairs, they'd be probably in court now facing charges for killing 5 or 6 people by not applying the relevant advice. So the failure really was policymakers and senior people within the fire brigade in the years before not making plans for a building failure, not the individual firefighter on the ground, not kind of improvising those plans in the moment, is where I put it.
Great. Simon Faulkner's just left a comment basically saying aesthetics over safety. Hopefully lessons have been learned, which I think we can all definitely agree with on that one in particular.